When a parent in a divorce wishes to move a great distance inside the state of Colorado or even out of state, if it is the first custody determination, the court is really just going to be looking at the best interest of the child. Where is it in the best interest of the child to be? Because let's face it, if the parties were still married and they were going to move, the child would move with the parents when they do that. So the court will just simply look, as it would if the parents were going to be close by, as to a custody determination or parenting time determination, what is in the child's best interest. The only difference is that when the distance is too great, the presumption or the predisposition towards a equal or roughly equal parenting time, a 50-50 type schedule, must be disregarded because the distance wouldn't allow that, right? You can't have a child in Durango going to one parent and then living in Fort Morgan the rest of the time and going to the other parent, and going to school in Morgan County and Montrose County. That won't work. The court engages in simple best interest of the child test to see where the child will be spending what will amount to a majority of their time and figure out how the other parent can have parenting time with the child during the remainder of the time. Very often an example would be that wherever the child is going to go to school, the other parent will have the child during most summers and other vacations and holidays to try to equalize things as much as possible. If the relocation is happening once there's been an initial parenting time decision and award of parenting time and a parenting time schedule and all that stuff being done, and then this is done in a modification, then the court has to apply a different standard where they're looking at this as a relocation, and the court is charged with determining a variety of factors, and the court must make findings of fact as to each of, I believe it's 17 different factors at this time, that must be considered and decided before making the ultimate decision as to where it is in the best interest of the child to relocate or to not relocate. When a parent wants to move out of state, it isn't really that different than moving a great distance within Colorado. I mean, let's face it, the two corners of Colorado, or any two corners of Colorado, are farther apart than most states are farther apart from one another. Colorado's a pretty big state. So, depending on the distances involved, the calculus is not that different. The only real difference is that the court, particularly in a divorce, can order, and in fact, in the mandatory orders at the beginning of a case, does order that neither parent is to remove the child from the state or to move out of state with the child until there's a custody determination. Court can't make that decision within the state, but can make that decision without the state. And so the parents are restricted during the initial divorce period from moving the child permanently out of state during that time, without further order of the court anyway. So that is one place where it is a little bit different. But then when it comes to actually making the decision and the determination, really distance is distance. And the more distance that there's going to be, the more challenging it's going to be to set up a parenting time schedule. But at some point it becomes very similar. Whether a Denver child has a parent that's moving to Durango or moving to Salt Lake City, not that big a difference as far as logistics are concerned, just because one is out of state and one's not. When a court is faced with a relocation and having to determine parenting time and parental responsibilities, once the decision about relocation has been made, the court applies really the same standards at that point. The predisposition is to maximize the amount of time that the child spends with each parent, gets to have with each parent. But because of the new distance involved, of course, a 50-50 schedule is not really going to work. And so the court will look to other ways, and hopefully the parties will look to other ways and agree on other ways to try to maximize that time when it can never be equal, right? So the child's going to end up going to school in one school district. Maybe the child's going to need to spend more vacations, summer vacations, and other vacations with the other parent who's not living in the school district. And the same thing goes with decision making. I mean, these days, with the level of communication and the quick communication and review of medical records and review of school records, and the ability to talk with extracurricular coaches and even with religious leaders, the ability for parents to continue to make joint decisions is not impeded. But the court may put some fail-safes in place, like being able to make emergency decisions while the other parent's far, far away, particularly regarding medical decisions, so that the medical care of the child's never impeded by the distance of the parents. But so decision-making is not hugely affected by the fact that one parent relocates, but the parenting time becomes a much more challenging puzzle to put together. And even though we all will then acknowledge that equal time would be very difficult, the courts and the parties should consider other abilities to maximize the child's time with the parent that's been left.